Dave Barham. Nice to meet you, Peter.
Yeah.
And you are with?
I'm with McGinnis Cooper.
Okay. Okay, right on. Yeah.
I'm a little familiar with this.
I'm sure. Yes, yeah. Morning.
So we can call the meeting to order at your pleasure.
Sure. He's here. I've seen him. Why isn't that coming on? I tried putting my password in here and still not.
See if IT can come over.
After I put the password in.
It just should click on that arrow there.
That's what I did the last time, but it didn't seem to make any difference. Oh,
there you
I'm good. I'm good. Got everybody here? Okay. Good. Okay, good morning, everyone. Are we missing Riley? Okay. I guess we're going to call the meeting to order, and we'll move forward. This morning we have Peter Rogers from McGinnis Cooper Municipal Solicitor for a presentation, and I presume Riley is right around here somewhere. Okay, yeah, caught in traffic. So I think we'll go ahead and start.
Pleasure to be presenting here for you. I have 4 slide decks to present this morning, but we'll start with the longest one first, and hopefully the other ones will move fairly quickly along. This first slide deck is really dealing with the legal environment in which you operate, to make sure that you understand the constraints, some of the constraints, because we're not going to deal with them all, but some of the constraints imposed by law on the municipal corporation and on councillors specifically. And it is important to be aware of some of these things. There are a vast number of legal constraints, so I'm only going to be touching on some of the main ones. Now, let's see if I can operate the technology. It's often said, in fact, you can find it in many, many reported cases about municipalities. Municipalities are a creature of statute. And what does that mean? That means that, unlike the provincial legislature, unlike the federal parliament, municipalities have no constitutional status whatsoever. And all of your powers are derived from statutes, primarily the Municipal Government Act, but other statutes as well. All of them are derived from statutes, and because the Constitution allocates the subject matter of local government to the provincial legislature, when it's dividing the powers, as it does, the Constitution Act 1867 divides the powers between the federal government and the provinces. As I say, the municipalities don't appear in that mix. The whole universe of subject matters of legislation is divided into those two levels of government. And under Section 9216, local government is a matter within the exclusive legislative jurisdiction of the provincial legislature. And so the province, in many ways, is your boss. They have very strong powers. They choose to give some of those powers to municipalities, and they can give them and they can take them away. Council has been given powers on specific matters. I mean, to pick a very granular one, it has given the power to municipalities to deal with the demolition of dangerous and unsightly buildings. And in fact, within Part 15 of the Municipal Government Act that deals with that subject matter, certain things can only be done by council, like the actual demolition of buildings, but other things dealing with dangerous or unsightly premises can be dealt with by a statutory authority called an administrator of dangerous and unsightly premises, one of your staff members who has specific powers given to him to deal with those matters. So in addition to having, and that's just one of many examples, of course, in addition to having specific statutory authority on particular subjects, you have a general authority as the governing body of the municipal unit. And by a governing body, I mean in some ways similar to a board of directors of a corporation. And you will find, in some cases to your chagrin, you will find that the municipality not only has powers and authority, but it also has many, many obligations which are imposed by the province, by laws, particularly the Municipal Government Act and regulations. There are many, many obligations imposed on municipalities that you can't get out of, even if you would rather not be dealing with the subjects that fall under that heading. You don't have a choice about administering the building code, for example. You have to do it. It's assigned to you. It's part of the municipal responsibility. And when I say you in this case, most of that work is done, almost all of it is done at the staff level by building officials who are themselves statutory authorities, a term I'll be using several times. Your spending powers are governed by the Municipal Government Act, sections 65A. At one time, there used to be a huge, big, long list of all the things you could spend monies on, very detailed list. That list had to be amended so many times that I think the legislature and Department of Municipal Affairs got tired of doing that. And so now they've left it fairly general in terms of what you can do. But that long shopping list, which predated the amendment that came in when 65 capital A was enacted, that long shopping list of powers is still a useful thing to look at. Lawyers such as myself would look at to determine, when I'm advising you and your staff, I would look at it to determine, look, has that historically been recognized as a spending power of the municipality? And the legislation specifically says you can look at that for guidance. You can only borrow money for capital purposes as authorized by Section 66 of the Act. You cannot budget operating deficits, unlike the senior levels of government, which extensively do run operating deficits. With one particular exception, a relatively new one found in Section 71 capital C of the Act, with this one possible exception that applies to phase assessment increases in commercial development districts, the Act prohibits tax concessions or other forms of direct financial assistance being given to for-profit companies. In other words, to any kind of a company that is not operated as a nonprofit society. And with respect to nonprofits, the legislation provides details on what powers you have to make grants to nonprofit organizations. You have the power to expropriate property, and property doesn't just mean a lot of land. It may be that you need to expropriate an easement to run a sewer line over somebody's property. That is a taking of a property right of the landowner if you're doing that. And the Municipal Government Act in Section 52 gives you the power to do that. However, those powers are intensely regulated under the Expropriation Act with a very detailed regime to ensure that the landowner is compensated according to what the legislature considers to be a fair system.
Excuse me, Peter, if you don't mind, just
Sure.
interrupt for a second. The rookie chairman failed to call roll call at the beginning, and I just want, for the verification for the minutes, can I just declare that all members of council are here, or do we need to take a roll call? We're okay? I'll refer to you, Emily. You like the, you know what the, you, can I just declare that everyone's here? Done.
Part
That's-
matters.
All right, thank you. That's what we'll do. I just declared that everyone's here. Sorry, Peter, but now they, for the sake of the minutes, thank you.
No problem.
All right.
So resolutions or motions, it's the same thing. These things are the same. Different people call them different things. But resolutions are the ordinary means by which council takes action and makes decisions. Not all motions have to be on substantive subjects like, you know, whether to fund this organization or that. Some of them may just be on procedural matters. There are things under the Municipal Government Act called policies. They're a type of motion requiring a special procedure additional to the ordinary procedure that applies to resolutions. They require more notice. And I should say that even though the term policies are used, not all of these things look and feel like policies in the layman's sense. They, in some cases, contain a lot of detail on implementation. A policy with a capital P under the Municipal Government Act is essentially just a special type of resolution, and the Municipal Government Act provides certain things have to be done by policy, but other things which can be done by resolution are allowed to be done by policy as well. Bylaws are subordinate legislation. In other words, they're like regulations, but traditionally in municipalities, they're called bylaws. Bylaws have to be enabled by, and they have to be consistent with, provincial legislation. For the most part, these are governed by the Municipal Government Act again, although there are some policies enabled by other legislation. And I meant to have a bullet in here, and I don't see it, but I meant to have a bullet pointing out there's many other pieces of legislation that do directly impact upon municipalities. Some of them are fairly odd things that you wouldn't expect to be there, but the Motor Vehicle Act, for example, does contain some bylaw-making powers. And there's many other pieces of legislation that have impacts on municipalities, like the Municipal Elections Act, which probably some of you are familiar with from recent times, Municipal Grants Act, Municipal Finance Corporation Act, and Municipal Conflicts of Interest Act, which I'll talk about on another slide deck. So there are many, many pieces of legislation, but in this slide deck, when I'm talking about the Act, I'll be speaking about the Municipal Government Act. So bylaws have to be consistent with and enabled by legislation. You can't create a conflict with provincial legislation. Again, remembering the constitutional hierarchy, they're at the top of your hierarchy, and you can't conflict with what the legislature has dictated. The procedure for enacting bylaws is more elaborate still than for policies, and therefore even more elaborate by far than resolutions. Requires 2 readings, publication of a notice so that the public is aware that there's potential to enact subordinate legislation. In some cases, the province has the opportunity to invoke provincial interest to cancel out or deny the authority to pass a bylaw. And finally, there's a step of requiring publication in the media once approval has been given by council for bylaw following a second reading. Planning documents are a particular type of bylaw, and they include a municipal planning strategy. That's a set of policy documents that are there to guide the implementation of municipal planning policy. The Act requires you to have a municipal planning strategy, and it even requires you to deal in your strategy with particular subject matters. The land use bylaw is an implementing bylaw that implements the planning strategy. And to some extent, the subdivision bylaw does that as well, although it also implements provincial subdivision regulations, which you can't contract out of or eliminate by your own legislation. So land use bylaw applies when somebody wants to carry forward a development. Let's say you're in a particular zone. The land use bylaw specifies what types of development you're allowed to undertake in that zone. And some of them you can do as of right, which means you can go in to the office here and consult with staff, a development officer, and the development officer would say that's permitted under the land use bylaw because that's a permitted land use in that zone. In some instances, there are provisions in the land use bylaw that require a special type of process, a development agreement process, or there may be a requirement to get a rezoning in order to do a development because the permitted uses within the existing zoning don't permit it. And the municipal planning strategy guides what types of things you need development agreements for, what types of things would require a land use bylaw amendment or a rezoning, to use the colloquial term. These types of bylaws, because they're implementation ones, the land use bylaw and the subdivision bylaw, they're more granular and detailed. They shouldn't contain subjective standards, whereas the municipal planning strategy, it's a policy document. It has a lot more subjectivity to it. In other words, value judgments are called for when you're interpreting the municipal planning strategy, because you'll see words in there like whether a development is compatible with the existing built form. You'll see wording in there like whether a proposal for a project is premature or inappropriate. Those are all subjective criteria. They're not things you can find the answer to by just having a tape measure. And I often used to say about land use bylaws, just to illustrate the contrast between these two different types of planning documents, a development officer should be able to, and they may correct me on this, but a development officer should be able to interpret and apply the land use bylaw, in other words, to make a decision on a land use bylaw application, with nothing more than the land use bylaw, a tape measure, and a site plan. It should be black and white. It should be not full of subjective standards like it's appropriate or that kind of language. Council itself, this body, is the designated authority to interpret the municipal planning strategy, albeit with staff assistance. You'll always have a staff report to guide you in your interpretation, and that staff report is prepared by professional planning staff with education specific to the subject matter of land use planning. And your staff also is aware of the whole document, because planning strategies should be interpreted in a holistic way, and these are documents that are, you know, about 1.5 inches thick or 1.25 inches thick. So there's a lot of stuff in there, and your professional staff knows when there might be something at the back of that document that impacts the interpretation of something, you know, in the second chapter of the document. So you're the designated authority to interpret the municipal planning staff, and you have a couple of occasions when you have that role before you. One of them is when somebody applies for a development agreement, and another one is when somebody applies for a rezoning that is sort of a site-specific rezoning that's not requiring an amendment to the planning strategy itself. So in those circumstances, you get these planning applications before you, and you have to have a public hearing, which we'll come to in a moment, and you act in that context like a quasi-judicial or court-like, judicial being court. It's sort of like a court-like role. You're having a hearing. You have to honor some due process requirements and other procedural requirements. And your authority in interpreting the planning strategy in those two contexts is subject to the right of aggrieved persons, which would include usually the property owner and some neighboring property owners, to appeal your decision to the Utility and Review Board. That's happened, I would say, about 6 to 8 times maybe in the last 9 times in the last 4 years. Yeah. So, and those are court-like processes. I've been doing a lot of them myself, and they involve multi-day hearings usually, and briefs, just like you would do or a lawyer would do in a court proceeding. So I've mentioned already a couple of statutory authorities. You are a statutory authority when you're engaged in a role like the ones I just described. You are a statutory authority yourself, collectively, council is. But council isn't the only one. I mentioned building officials. I mentioned, I think, the dangerous or unsightly premises administrator, building officials, development officers. There's a responsible officer for the Freedom of Information and Protection of Privacy sections of the Municipal Government Act. That's Part 20 of the MGA. It's quite a thick part. It's very dense. And so you have a responsible officer who deals with those applications in accordance with the law. You have a returning officer under the Municipal Elections Act. You have a municipal engineer with certain powers that are afforded under the Municipal Government Act. And you have a traffic authority whose authority comes both from the MGA and from the Motor Vehicle Act. These are all statutory authorities in their own right in their particular settings. And a statutory authority has to exercise their professional judgment in accordance with how the mandate is framed in the legislation, and council has no role in directing how they fulfill their responsibilities. The intention of the legislature in creating these statutory authorities is to have those statutory authorities exercise their own professional judgment without interference from the elected officials, as long as they're acting within their defined mandates. Employees. I don't have to tell you, a municipality in this day and age has many employees. Some of them in this municipality are unionized, and therefore they must be handled in accordance with the collective agreement and the Trade Union Act. Neither council nor the CAO are guarantors of their performance, although it is the case that the municipality can be liable in the event of wrongful conduct by staff. The Municipal Government Act is very explicit about not allowing council involvement in performance issues for any employees, with the singular exception of the CAO. And that's because it implemented, ever since its enactment in 1998, and it was a sea change when this occurred. Sadly, I'm old enough to remember it quite well, but it was a sea change, and it enacted a Carver model, as some people call it, in which authority of the governing body is entirely passed through the CAO in respect of other employees. Council, even as a whole, sitting as a whole, has no authority to deal with any employees except for the CAO himself. And it follows from that council collectively gives direction to the CAO. You don't, as individual council members. It's not the role of an individual council member to give direction to the CAO, but collectively you can, and sometimes that's done in camera, and sometimes it's done at public meetings. We'll have a slide deck on in-camera meetings to deal with that aspect in more detail later on. So even information requests, a councillor may want some information, may go up to staff and say, I'd like this information. You should expect that the staff member may run it past the CAO to make sure that the CAO provides authority for that information request to be honored. And that's because some requests for information may overstep by either amounting to an implicit direction rather than just an information request, or because the information request may consume a disproportionate amount of resources beyond the intended mandate. So the staff-council relationship, it should be a reciprocal, supportive relationship. Council, ideally, will support staff. Staff are the means through which your decisions are carried out. Again, through the CAO to staff. That's how they're carried out. But recognize, as we've already indicated, staff also have to carry out other obligations imposed upon them by law. Staff ideally supports council, so this is the reciprocal nature of the relationship. Staff ideally supports council by providing good recommendations, good information, and reports on issues of concern, albeit within the limitations imposed by resource constraints. And with respect to this relationship, it's useful to bear in mind, everybody should bear in mind, both staff people and council members, that public in the current social media era has become increasingly vocal and feeling like there's little constraint upon them in making criticisms, and that they may be criticisms about staff, they may be criticisms about council, but be mindful of that. And obviously you want to have good staff, you want to have staff who are not going to be intimidated by the fact that inevitably there will be members of the public who are unhappy with some aspect of municipal decisions. And it shouldn't be a situation where staff is personally being attacked. And hopefully the same is true of councillors as well when they're discharging, when you are discharging your proper functions. There are privacy rights that you have to keep in mind and you should be aware of. Personnel matters are generally confidential, with very limited exceptions for things like sunshine lists, as they're sometimes called by the media. But because of employee privacy rights, personnel matters are confidential. Breach of privacy rights is a statutory offense. In other words, you can be convicted of that. A person who breaches it can be convicted of it. And in recent years, it has also been recognized as giving rise to civil damages lawsuits. You should also be conscious of avoiding commentary about staff which may lead to human rights complaints, harassment complaints, constructive dismissals. That's when somebody says the toxic work environment or whatever caused me to resign. Even though I resigned, it's not a true resignation. I was basically forced out by this toxic environment. Another thing to avoid are just generally any kind of employment law complaints, as well as code of conduct complaints, which is a subject I'll be going through within this slide deck at some length later in the presentation. So I mentioned FOIPOP is the abbreviation commonly used. There is a FOIPOP Act that applies to the provincial government sector. For the municipality, there are many very similar provisions to the FOIPOP Act that are found in Part 20 of the Municipal Government Act. And it has the two components which are different. One is an access to information component, and the other is a protection of privacy component. So both of those different values are at the center of the FOIPOP provisions of the MGA. And you need to be aware that what you say or write in your capacity as a councillor may be the subject of an access to information request by the public. And it may be useful if you have concerns on the subject, have a look at the Office of the Information and Privacy Commissioner website, and I know they have handouts as well with information on the Privacy Commissioner's views on how the Privacy Act provisions apply. You should not assume that communication sent by Gmail accounts, for example, or Hotmail or other types of non-municipal email accounts, or that communication sent by text message are immune from being compelled by process of law. They can be, and it can be very embarrassing to be forced to produce those, particularly if they were sent on a back channel for a reason involving a hope that they won't see the light of day. In addition to employee privacy rights, there's others who have privacy rights. That would apply for things like names and phone numbers on forms, police informant privilege, intellectual property, financial information. So it's not just employees, but other parties with whom the municipality deals that have privacy rights. And the municipality has an obligation to protect third-party privacy interests, and it requires that there be due care taken. And in particular, this last bullet point is to highlight that private email accounts are inappropriate to use for any privacy-protected documents with confidential or personal information. You know, personal information can include something as banal and mundane as a person's address. Defamation, most people have heard of libel and slander. Defamation deals with both categories, verbal and written comments that are damaging to a person's reputation. When you're in a council meeting and you're discussing an issue, you have a qualified privilege from liability for mistaken but honest comments made in the council meetings. If you go out after the meeting and say the same thing to a reporter outside, or put something in social media on it, you are not guaranteed any shield of qualified privilege, and you may bring liability upon either the municipality or yourself or both. And you should be aware that there is quite likely no municipal insurance policy that protects you from lawsuits for defamation or cyberbullying, and even your staff can sue council members for defamation. That happened in St. John, New Brunswick, over, I think it was a pension committee there. Millions of dollars were spent in litigation in that particular case. There are, and this is certainly a bad news slide deck, sorry folks, but there are other possible sources of legal liability that you should be aware of. You can be sued for other types of torts. Defamation is a tort, the one we just talked about, which is saying something damaging about another person's reputation, which is not justifiable by being true or subject to any other defense. That's just one tort. There's other types of torts that apply to people in the municipal world, including abuse of public office, and there's even criminal offenses that can apply. Councillors can be prosecuted for things like fraud, bribery, breach of trust. But I'm not going to spend more time on this slide deck, because the real point is, if you adhere to a reasonable standard of ethics and integrity, you should have nothing to fear from those things. Okay, and here's a portion of the slide deck that I prepared recently, because this is a very recent subject matter. The municipality has an existing code of conduct policy, but that code of conduct policy will be replaced by a provincially dictated policy, and that province-wide code of conduct for council members has been adopted by provincial regulations, which are mandatory for council to implement with a deadline, I believe, sometime in December. So you'll be seeing a motion to adopt the code of conduct, because the province has basically said, you have to enact it. What's the purpose of the code of conduct? It's to establish guidelines for the ethical and responsible conduct of members of council, and to provide a process for determining the validity of complaints under the code, and for council to impose sanctions where the complaint is found to be valid. There will be mandatory training apart from this session. It's being prepared by the Nova Scotia Federation of Municipalities. I don't believe it's available yet, but hopefully they'll be rolling that out soon, since the program itself, the code of conduct itself, will have to be adopted before the end of the year. So the code of conduct sets forth a number of principles, and the purpose of having these principles, as I interpret the regulations, the purpose of having these principles is to serve as an interpretive aid in applying the much more detailed prescriptions of the actual code of conduct. So here they are: collegiality, Members of council will work together to further the best interests of the municipality in an honest and honorable way. These are direct quotes from the regulations, by the way. Respect. Members of council will demonstrate respect towards one another, the democratic decision-making process, and the role of staff. Integrity. Members of council are expected to act lawfully and adhere to strong ethical principles by giving the municipality's interests priority. Professionalism. Members of council will create and maintain an environment that is respectful and free from all forms of harassment, including sexual harassment and discrimination. They must show consideration for every person's values, beliefs, and contributions. Transparency. Members of council will be truthful and open regarding their decisions and actions and accurately communicate information openly to the public. Now, that one we'll see is subject to legitimate in-camera meetings, which, as I say, we'll deal with in another slide deck. The sixth principle is responsibility. Members of council are responsible for their decisions and are accountable for their actions and outcomes. Councillors must demonstrate awareness of their own conduct and the effect of their words or actions. So quite lofty principles, but they're used to interpret the very specific standards. And there's quite a few slides in here on the actual standards, and I think it's important you be aware of them. I've had to boil them down a small amount. I've tried not to boil them down too much, but just to get them on the slides, I had to boil them down a bit, combine a couple of them as though they're a single standard. Members of council must be truthful and forthright and not deceive or knowingly mislead council, the CAO, or the public. Members of council will respect the presiding officers, the chair of the meeting, whether it's a council meeting, a committee meeting, or whatever. Will respect their colleagues, will respect staff, and members of the public that make presentations. So if somebody comes in to make a presentation, even if you think it's off base, it's to be treated with respect and politeness. Members of council must conduct council business and all of the members' duties in an open and transparent manner, other than for those matters which council is authorized by law to deal with in private, by which they mean in camera. Members of council must ensure that they're not impaired by alcohol or drugs when attending any meeting of the municipality. No member of council will disclose any confidential information acquired by virtue of their office, except where required by law or authorized by the council to do so. So that one is reinforcing the principle of in-camera meetings, which you're required to honor. No member of council will use confidential information for personal or private gain or for the gain of any other person or entity. Members of council should not access or attempt to access confidential information in the custody of the municipality unless the information is necessary for the performance of their duties and access to it is lawful. So you shouldn't be going in, you're curious about what your neighbor's doing over there, you shouldn't be going in and trying to dig out whatever development permit application they may have made. That's not appropriate. And this standard, it reminds me of issues that arose in the healthcare setting where, you know, some staff members of a health authority were going into other people's medical files out of curiosity, and that's a no-no. No member of council shall accept a cash, gift, or other benefit that is connected directly or indirectly with the performance of their duties of office, except for authorized remuneration and authorized expenses and certain specified minor mementos. So, you know, maybe if you're recognized after X number of years of service by being given a token gift, you're allowed to have that, but that's the limit of it. And that same standard applies not just to you, but to your family members and friends. No member of council shall use for personal purposes any municipal property, equipment, services, or supplies. No member of council or no person closely connected to a member shall tender on items such as the sale of older and extra equipment owned by the municipality. So you have to be careful, even though a tender process, you'd think it's wide open. This standard here is trying to avoid having the impression being given that maybe council members have more ready access to tender awareness, I'll call it. And this standard is in there to limit your conduct in relation to that. No members of council shall solicit or accept support in any form from an individual, group, or corporation with any building, development, planning, or procurement proposal before council. So there's lots of people who have applications before council, and a lot of them care, a lot what the outcome is, and you mustn't solicit or accept support. No member of council shall use the influence of their office for any purpose other than the exercise of their official duties. No member of council shall allow the prospect of their future employment by a person or entity to affect the performance of their duties to the municipality. So there has to be, you should not be trading prospects of, what you might do after you're no longer a council member with somebody who's got dealings with the municipality. Doesn't mean you can't go to work in another job after this job, but you can't allow that possibility to guide, how you're making decisions or how you're performing your duties in this job. No member of council shall borrow money from any person who regularly does business with the municipality, except publicly traded financial institutions, things like banks, credit unions, and so on. No member of council shall act as an agent of a person or entity before council or a committee of council or any agency, board, or committee of the municipality. And if we think of, I mentioned the planning hearings, for example, and you have some landowners who, they don't have the resources, or they don't want to have to hire a planner or a lawyer to go in and make a presentation about their project that's before council, then certainly no member of council should go in and serve as their agent to do that, as a spokesperson for those people. And no member of council shall attempt to influence any municipal employee to hire or promote a person closely connected to the member. So an anti-nepotism provision there. Members of council will adhere to the code of conduct and the policies and bylaws of the municipality, including expense and hospitality policies. I don't know the granular details of those, and I'm not sure whether there's a slide deck educating you on those from somebody else, but there are policies about expenses and hospitality policies. Members will adhere to the laws of Canada and Nova Scotia. Members of council must not encourage non-compliance with a statute, regulation, bylaw, policy, or procedure. So you can't tell somebody, oh, go do that. You probably won't get caught. A member of council must abide by and act in accordance with any decision made by council, whether or not the member voted in favor of the decision. So this is similar to what you would expect of a corporate director. Once a decision is made, you should be honoring the decision of the majority of your fellow council members and abide by and respect the implications of majority rule at the council level. No member other than the mayor must claim to speak on behalf of the council unless the member has been expressly authorized to do so. And when the mayor's doing so, he must try to accurately reflect the intent of the council decisions that he's speaking about. Members of council must respect the role of the CAO as head of the administrative branch of municipal government and must not involve themselves directly in the administration of the affairs of the municipality, including, without limitation, the administration of contracts. No member of council shall direct or attempt to direct the CAO other than through a direction provided by the council as a whole. So same thing that I was talking about before. That's already essentially part of the Municipal Government Act. But this has code of conduct sanctions attached to it. Members of council must not direct or influence or attempt to direct or influence any municipal employees in the exercise of their duties or functions, nor direct suppliers, contractors, and consultants of the municipality to do so. And of course, the municipality has many suppliers, contractors, and consultants. I'm in that category myself. And so this is saying you're not supposed to influence people who have that type of dealing with the municipality. Members of council shall refrain from making public statements that are critical of specific and or identifiable municipal and employees and or service providers. So that's an important one that again reflects some of the material that I covered under the MGA. No councillor should discriminate or harass on grounds protected by the Human Rights Act. And if you don't know what they are, you can go online. There's now a wide variety of characteristics about which there is to be no discrimination. There's not to be any sexual harassment or creation of a poisoned work environment. And there should be no reprisal if somebody has complained. Under the Code of Conduct, you shouldn't engage in reprisal against that complainant party in respect of other dealings that you may have with that person. So what's the process for dealing with these Code of Conduct complaints? So the process mandated by the regulations is that the municipality appoints an outsider as an investigator. That investigator receives the complaints, and their name and email address will be posted on the municipal website, and the complaint will go directly to that outside investigator. That investigator has to be somebody who has some experience in doing investigations. And, you know, that has been, I guess, an increasing growth area. Employee investigation is often outsourced in other contexts, and that process is being used here in what I will call the equivalent of a professional disciplinary process. That's what this Code of Conduct is. There's a time limitation for making complaints. It has to be made within 6 months of the conduct complained of. And if it's like other types of limitations like this, if the complainant had no way of becoming aware of the alleged wrongful conduct within that 6-month period, that will be extended. The investigator can dismiss complaints summarily, and there's lots of circumstances when I would hope an investigator would do that. People don't always complain in good faith. They may be complaining because they're unhappy with the decision that the council made, and they may feel some particular councillor should be made to suffer for it and lodge a complaint, and it may be a spurious complaint. In other words, one that has no merit having regard to those standards. And the investigator, if it's apparent on the face of it, is allowed to dismiss that complaint without going through with the elaborate investigation and decision-making process that otherwise applies. But when the investigator doesn't dismiss the complaint and goes on to carry out an investigation, the council member whose conduct is complained of is notified of that, and so too is council in camera. They're notified that there's an investigation underway. They aren't notified of all the details. Confidential information about the complaint and about the complaining person, the complainant, is protected by the investigator to the extent possible while honoring the due process rights of the counselor who is the object of the complaint. The investigator gives a report to council in camera within 6 months with recommendations regarding the merits of the complaint. In other words, was there in fact in the investigator's analysis and conclusion, was there a breach of the code of conduct? And secondly, also makes recommendations regarding the sanction or penalty to be applied where applicable, obviously where there's been a finding of a breach. The counselor whose conduct is complained of, who in this slide deck I sometimes call the complainee, can make submissions to council responding to the report of the investigator. The council determines if the code of conduct has been breached, so they've got a recommendation from the investigator. The council considers, as a peer group, much like other professional regulation bodies, like my regulatory body, it's a group of lawyers that determines whether, you know, I have breached my code of conduct for lawyers. So along the same veins, it's council who makes the ultimate decision about their peer, their fellow council member. And council makes that decision without the presence of the either the complainant, if the council member is a complainant, or the complained of counselor, the complainee. So those people don't participate in that determination because, of course, they have a conflict of interest. One of them wants, presumably, to have a finding that there was a breach and sanctions to be imposed, and the other one has the opposite perspective. And because they're the affected parties, they don't participate in that process. And this is all within the in-camera setting, at least until council's decisions is made. Once council makes a decision on disciplinary liability, in other words, whether there's a breach of the code, and on sanction, then the investigator's recommendations are made public, and so too is council's decision. Under the regulations, council's decision is final. Lawyers like me know that doesn't necessarily mean it's completely final, but it's final unless judicial review is undertaken by a superior court of the decision of council sitting as the statutory authority to deal with code of conduct matters. There's 13 sanctions. I haven't put them all on the slide. Obviously, one of the main sanctions is the very fact that the decision is being made public. That's a big sanction. The public is being told this counselor breached the code of conduct for council members. That in itself, that's an automatic sanction that just comes with a finding of breach of the code. In addition to that, the council is authorized to issue a public censure about the council members' conduct. It can authorize, and in fact I think it's required in some circumstances to require mandatory training. So even though you've had some training already from me, and you're going to get some more from the Federation, they can authorize you to go and get training on, sensitivity training on how to deal with people so that you're not rude to them and blow your stack when they say something you don't like. The sanctions can include a requirement that the counselor found in breach acknowledge the breach, that they breached the code of conduct, and apologize to the affected individuals. A fine can be imposed of $1,000. There can be a suspension of some remuneration that the counselor would be otherwise entitled to, like your regular remuneration as a counselor, for a period of 6 months. And you can be suspended from various positions that you serve in as counselor, like maybe you're a committee chair, maybe you're on a particular committee, and that sort of thing. Those can be suspended. Those roles can be suspended as well. And if it happens to be a financial type of a breach, what you might call a corruption type of a code of conduct violation, there can be repayment of the municipality's losses or the disgorging of any benefits, any financial benefit that the offending council member received as a result of his or her conduct. And I think that brings me to the end of my slide deck, but I'd be happy to entertain any questions that you may have. I will reserve my right not to answer necessarily all of the questions in a public forum. Most of the time when I'm giving legal advice, I'm doing it in camera, and it's appropriate to do it in camera. We're waiving that for the purpose of the slide deck, and I'll use my judgment on the questions to see whether I'm comfortable answering them in a public forum without the usual solicitor-client privilege, which is a privilege that is designed to benefit you as a counsel. So, happy to answer any questions you may have about the slide deck.
Do you have any questions? Councillor McPherson.
Thank you, Mayor. Through you to the solicitor, is that the title? Yeah. There can be varying degrees of breach of code. I'm curious, does the counselor always assume their role during the investigation, or may there be circumstances whereby a counselor actually withdraws for a period of time, or is forced to withdraw for a period of time?
I don't think there's a provision for interim suspension. I didn't see it in the regulations. They do have that in a lot of professional disciplinary practices. I didn't see that in the regulation. These regulations are being adopted on I'll call it on a trial basis for a 2-year period, and supposedly they will be revisited after that to see what's working and what isn't. But that's a good point. There may be circumstances where it would make sense to have an interim suspension. But that's not provided for, as far as I could tell. I didn't see any right for that. That doesn't necessarily mean, let's say the impugned or conduct, the allegation centered around a particular subject matter, it may be in the counselor's own best interest to declare a conflict if that subject matter is reappearing before council in some fashion. That would likely be wise for the counselor to do that, but that's an excellent question. Thank you for that.
Councillor Lutz.
Thank you, Mayor. Through you. I was curious, I remember a situation several years ago when we were looking at the secondary plan in New Minas, and we sort of created a new zone around a lot of different zones and made some wholesale changes. And there was someone at that time who had owned property that recused themselves from those discussions due to ownership of some of that land and potential zoning changes around that. Is that captured within the code of conduct? Like, you had sort of talked about it earlier in the presentation when we're making decisions around land use and land that potentially some of us could own, or, so I'm just curious, like, what, is that a code of conduct, or is that separate, is that a separate sort of offense?
Okay, I'll start. That's a good question. I'll start by saying it may actually raise issues under the Municipal Conflicts of Interest Act, which is a separate slide deck. But these are not what I call watertight compartments. So many of the things that are dealt with in the MGA or in the Municipal Conflicts of Interest Act or in other laws are also embodied here. And this may be a process that ends up being used more than the Municipal Conflicts of Interest Act, which is actually quite an old piece of legislation now, uses, you know, some outdated language and is less complainant friendly than this. So I'm going to answer yes. I don't want to give the impression that council members who own land can't have any dealings with planning matters. There's a whole range of I guess, degrees of specificity. The closer you get to dealing with a narrower class of matters, so you're into the secondary plan, so you know that's dealing with that one geography of the village of New Minas, and then you'd have to say, well, okay, is you know, somebody owning a house, you know, in the residential districts of New Minas, you know, are they conflicted from dealing with, you know, a commercial development issue on Main Street? And you know, my answer to that would be no, that they wouldn't be. But so it's really very dependent on the nature of the property owned and that and the nature of the matter that's before council.
Thank you.
Councillor Peckford.
Thank you, Mayor, through you. Kind of diving off that point a bit. If a councillor was looking to do a proposal for a rezone or development agreement in their own personal life, what's proper procedure for that?
The proper procedure for that is to remove yourself entirely from that decision process in your role as a councillor. So if you want to go ahead as a private citizen, because I know for many of you this is not a full-time job, you have another life and you have other interests, including business interests, to deal with. And you're not prohibited from going ahead with that, but you must never use your role as a councillor to try to get an advantage, like to get the ear of staff, to, you know, imply that you should be given, you know, a successful outcome because you're, you know, part of the council body as a whole. So, and I'll deal with this. I give a very detailed process thing when I deal with the Municipal Conflicts of Interest Act, because the example you're giving would fall right in that, under that Municipal Conflicts of Interest Act, and it would be dealt with by that. And as we'll see, the process is to stay away from trying to influence any other councillors or any other staff members regarding that application, and it's to declare a conflict at the very first meeting. If you're on the Planning Advisory Committee, maybe that's the first meeting. If you're not on the Planning Advisory Committee and you're simply sitting as a councillor, it would be at the first time that this development project came up to council, and you would declare publicly on the record that you have a conflict. You don't have to declare all the detail of it, but you have to say that's my or my family's application. I accordingly have a conflict. I'm going to recuse myself from this. Recuse, back away from, not involve myself, not try to influence anybody. And in fact, there's detailed process. You're supposed to remove yourself from the council chambers when it's an in-camera meeting, and if it's not an in-camera meeting, you're supposed to go sit down over here. Go get up from your desk and walk to the back of the room and sit there in the gallery to show, it's a means of showing that you're respecting this conflict of interest requirement. So I will get more detail. You'll see the detail on that in my conflict of interest slide deck. But that's a great question, and it's important to know those things because those are serious things. Councillors do get taken to task under that legislation. And as I say, this code of conduct process allows complaining parties, which can be anyone from another council member to a staff person to a member of the public who doesn't want to see your project going ahead, can be any of those people, can lodge a complaint here, and it's a fairly easy process for them in the sense that, you know, they don't have to hire a lawyer, they can put the matter in the hands of this investigator who will go carry out, you know, the functions of an investigator without much burden on the complainant. So, you know, I think this code of conduct is actually going to generate a fair amount of activity. I hope it doesn't generate, you know, what I call spurious or, complaints brought for purposes other than the intent of the code. That's my hope. I have some worries about it, but that's my hope for it. So, great question, but we'll deal in more detail with the process.
Just to repeat that, so if it is a non-in-camera meeting, if a counselor declared a conflict of interest, they could go sit in the audience.
Yeah.
If it is an in-camera meeting, they leave the chambers and go right outside of this room, correct?
That's exactly
Thank you.
right.
Counselor Sappington.
My question has to do with committees and boards and representing as a counselor. For example, let's say a policing board. So if a counselor was actually a police officer, would that be providing expertise to that committee or board, or would that be a conflict of interest?
Are you saying that the counselor in your hypothetical is a police officer?
Exactly.
Or was a police officer?
Is one currently.
Yeah, I mean, I would, if it was me, I would not want that appointment.
Thank you.
Counselor Peckford, get you to turn your, yeah. I guess that's good. That's all the questions, unless you got one, Mr. CAO?
If I could.
You can.
Thank you. So it's probably under your conflict of interest deck, but we're kind of talking about it here now. So when it's an in-camera, you leave the room. If there's no members of the public in the gallery, do you leave the room?
I'm sorry?
So we're in public session.
Yes,
The counselor would declare a conflict of interest and sit in the gallery.
yes.
What do you do if there's no members of public in the gallery? Is that an influencing factor? For example, do you then
I
leave the
don't
room?
think you have to leave the room. I mean, the legislation, the Conflict of Interest Act is very, it's sort of a black letter type of a piece of legislation. So it tells you to sit in the gallery. Well, you go sit in the gallery. You can't help it that nobody else is here. Yeah.
Okay, I don't see anyone else asking for questions, so I think at this time we'll declare a recess and meet back here in, 15 minutes? Does that sound reasonable?
Great.
Okay, thank you.
Thank you.
call the meeting back to order and ask you to continue. Peter, please.
Thank you, Your Worship and council members. So I've actually decided to switch the order of presentation because there were questions in particular on the conflict of interest subject matter. This slide deck is one that I prepared some time ago, but the Municipal Conflicts of Interest Act hasn't changed much over the years, I'm sad to say. But there are a few slides here on modern public expectations, which were designed to avoid getting into a bunch of problems that are now comprehended within the Code of Conduct. So I may go pretty quickly through the last slides that deals with modern public expectations about council members, because we've really talked about those at length through the Code of Conduct slide deck. And I meant to say at the beginning of the last deck that at least 3 of the slides that I used there had significant content from a slide deck that Mayor Muttart had prepared, I think originally in 2018, and I don't know whether it was used after that, but in any event, I want to give him credit for those slides. I think it was slides 3, 4, and 10. So this one is my own, pretty much entirely, although I will relate one comment that I did see on one of Mayor Muttart's slide decks that I agree with. So this is a separate piece of legislation. You won't find it in your MGA itself, but you can get all provincial statutes off the provincial website. I used to carry around a thick binder about this big with the MGA and the MCIA in it, because I've often had questions about the Municipal Conflicts of Interest Act. So again, I reiterate, this is an old piece of legislation that's still active, it's still used, complaints still arise under it. But it deals with a particular type of conflict only. What I'll call political conflicts, issues where there is a subject matter that is not involving a financial interest or a potential financial interest. Those things aren't regulated by this act. But I still recommend using where you want to recuse yourself, in other words, to disengage, to not be part of the decision process on things that don't involve this act. You can still, in my view, profitably use the provisions of this act and say, I'm going to declare a conflict and recuse myself. Even though I don't have a financial stake in it, I may be perceived as having an interest of another kind, a bias type of an interest or something of that nature, and possibly the type of situation that Councillor Sappington referred to as well. This act applies when you're sitting as council, it applies when you're sitting as committees of council, and it applies to other boards or commissions that are dealing with municipal matters or which are municipally funded. There used to be a lot more things like that. You used to be involved in hospital boards. Well, that's gone by the wayside. Used to be involved in school boards. That's gone by the wayside. So the other numbers of boards that you may get, boards or commissions that you may get appointed to, are more limited now than they were in the old days. And this is the biggest thing to be aware of. This first bullet point is so often overlooked. You know, you have other lives than being a council member. And having a conflict simply indicates you have an active other life that involves, you know, different sets of interest. Having a conflict is perfectly okay. It's just a sign that you have other interests. There's nothing at all wrong with having a conflict. So, you know, you don't wag your finger at somebody who declares a conflict because they have a conflict. That's not improper of them to have a conflict. Failing to declare it and failing to follow the process, that is wrongful conduct, and that's no good. So the key thing is to immunize yourself by declaring it and by following the process. Having the conflict is okay. Improperly acting on it, failing to declare it, not okay. A conflict under this legislation is, they use the word pecuniary, it's a Latin word. It means a financial interest. A conflict is something that a counselor or people who are related to the counselor in manners I'll describe in more detail have a financial interest in a matter which is the subject of consideration. And it doesn't matter whether the financial interest is direct or whether it's indirect, for example, shielded through a corporation, a partnership, a trust, or an employment relationship. And the financial interest may be a deemed interest. And I'm going to say it's a deemed interest where maybe you have somebody who's related to you with a prescribed amount of consanguinity, in other words, a relative of a certain amount of proximity to you. You're deemed to have a conflict, even if you don't like that relative and want nothing to do with them. A deemed conflict has to be treated the same way as an actual one. And there's some limited exceptions, which I'll get to. You are so indirect conflicts. You're conflicted in a matter in which the following have a financial interest: your employer, a business partner or joint venturer, a company in which you are a substantial shareholder or officer or director. Substantial shareholder means you have any shares at all in a private company. And by a private company, I mean a company that's not listed on the Toronto Stock Exchange or whatever the name of that exchange now is. And if you own 10% of a company, if you're lucky enough to own 10% of a publicly traded company, that too is being a substantial shareholder. But that's the key to remember about corporations. Most of you are more likely to be involved. I mean, you may own publicly traded companies, but I think it's probably unlikely you own 10% of GM or something. But you may well have a small corporation, a private corporation, one that's not publicly traded. Any shareholding is considered a substantial shareholding for purposes of this legislation. And it doesn't just include shares that you're on the share register of. It includes shares that are held by others for your benefit. So, for example, if you're the beneficiary of a trust or there's a family trust involved, that doesn't get around the problem. Volunteer organizations, these are difficult. There's some difficult issues here to deal with at times. If you're an officer or on the board, or in some instances just a member of a nonprofit organization, you are conflicted from dealing with matters in which that body has a financial interest. In other words, for example, let's say there's a grant application for a nonprofit in which you're on the board. Sorry to say you should recuse yourself, even though you would think that's the very thing you would want to be dealing with. I say just a member. The wording of the statute hasn't been perfected. They talk about member of a nonprofit. And if you think about some organizations, like maybe a fire department would be a good example, you can have an awful lot of members who really are not having a central role in the governance of that body. And, I think there is some latitude there for large organizations that have large membership, and you're just a member, you're not, a committee head, you're not on a board. There's some latitude there to say that you don't have a significant enough interest that's worthy of declaring a conflict. Family members, you're deemed, so I mentioned deemed conflicts. You're deemed to have a conflict if certain family members would be conflicted. Your spouse, you or your spouse's children, parents, or siblings, or their spouses, and anyone normally living in your home. You're deemed to have a conflict if those people have a financial interest in something coming before council. There's some exceptions. Interests in common with a large class of electors in general. You may be taxpayers. I'm sure many of you are. Doesn't stop you from setting the general rate. You can still vote on that resolution. There would be precious few council members to pass the tax rates if that weren't so. So that's an example. And I think Councillor Lutz touched on a situation where, for example, you may be a resident in a very large zone, like your mixed-use zone that you have here in the rural areas, A2 zoning. You may be a resident there. Does that stop you from voting on a municipal planning strategy that, tweaks the development rights of the A2 zone? In my view, it doesn't. It falls within the exception of interests in common with large class of electors in general. Interests arising from council appointments or to other bodies. Again, as I say, there's fewer bodies than there used to be, like the school board or the hospital boards. But if it's a board that you're appointed to by council, presumably to represent the interests of the municipality on that board, it's not considered that if they have a financial interest in something before council, you're not considered to have a conflict that requires you to recuse yourself. And then there's the third catch-all exception, interests so remote in this example of this very large fire department of which you're a member, interests so remote or insignificant in nature that they cannot reasonably be regarded as likely to influence the decision. Consequences of violation. The court can order forfeiture of your office and disqualification from future office. Very heavy potential penalty there. The court can order nullification of the council decision that was affected by your participation. And when we get to the process and how you recuse yourself and avoid influencing others, the theory of that would be, well, if you fail to do that, you may be an influential part of council. You may have influenced other people on council to support it. And so that can result in nullification of a decision, which can be a very serious matter after the fact. Having council's decision nullified can create significant liabilities for the municipality. Court can order restitution if you've made some kind of a gain or profit, and fine of up to $25,000 can be imposed. So here's the process, which I've already, I think, foreshadowed. When you are first aware that a conflicting matter may be coming before council or another applicable body, another municipal committee or organization, when you're first aware, you refrain immediately from attempting to influence the other decision makers before, during, or after a council meeting or any meeting. A lot of things go through multiple steps. So, these processes, and I gave the example, if you think of a council member who's on PAC, that matter is going to go at least once to PAC. Some of these things go multiple PAC meetings. You'll have at least, a first reading, and you'll have a second reading. And so there's multiple steps where you have to not be involved, and you have to engage your recusal from the very first meeting that you're at. That's when you declare your conflict. At the first meeting, you disclose the existence of a conflict and its general nature, and you indicate your non-participation. You say, I am recusing myself from this matter. Councillor Harding.
Yeah, just storage stuff to you, Mr. Mayor. What happens if you don't know at that first one? Yeah, I know you probably should, but what happens if you don't? Thank you.
Well, if you don't know before the meeting because you haven't had time to read your agenda package, which you now all usually do get in advance, as soon as you hear this is regarding, you know, the development project of so-and-so or the contract of the municipality with its, I don't know what supplier, pipe supplier, you say, gosh, I wasn't aware of this, but I'm now declaring before there's any further discussion on this matter, before there's any debate on it, I see it now coming forward, you know, I am declaring my conflict of interest. I'm recusing myself. And when I say to you, disclose the general nature, you say, I've got a family member who's involved in this pipe business, or I have, whatever the nature of that is. You don't have to say, it's my brother John, he owns 30, you don't need, no. Just the general nature of it, that suffices. You leave your council seat at that point when you declare your conflict. And that must be before the debate or discussion starts on the matter. And you sit in the public portion of the council chambers if the meeting is open to the public, or outside the chambers in the case of an in-camera meeting. And then you pay attention to the minutes, the draft minutes at the next meeting or whenever those minutes come forward for approval. And you make sure that your declaration and non-participation are recorded in the minutes before you approve those. You want them in the minutes. I think, and I'm sure the CAO or council members who are returning will correct me if I'm wrong, but I think there's even a standing agenda item at your council meetings that has declarations of conflict of interest in it. And so that's actually that's the best time to make this first declaration. It's when that issue first comes before council and you see declarations of conflict as a standing agenda item, you declare your conflict. Now, if you want to know whether you're in a conflict or not, I should have put in Mayor Moutart's advice here because it's such good advice. His suggestion is, if there's any question about it, just declare a conflict. Just do it. But if you really want to get advice and find out, is this truly a conflict under the Act or isn't it? Get your advice in advance of the meeting if you can, because it's going to be too late at the meeting. If you're getting advice, there's no point getting it without making full disclosure, because the lawyer is not bound, and I'm assuming you go to a lawyer, but maybe there's others you get advice from, but whoever it is not bound to honor the advice they gave you if you didn't make full disclosure. I have noticed some tendency dealing with councillor conflict issues, some tendency to soft pedal the nature of the conflict when they're seeking advice on it. You really need to avoid that. You need to make sure all of the worst possible facts that would be the worst ones if in fact it's a conflict, all of those should be disclosed to your advisor. For advice to be protected by solicitor-client privilege and confidentiality, you have to retain your own counsel to advise you. And incidentally, if the municipality gets advice from myself or some other municipal solicitor for Kings on your behalf, the advice will not be confidential from council and may even be publicly disclosed at the option of council. Who decides if you have a conflict? In its wisdom or lack thereof, the legislature has decided that it's the individual councillor who decides. It isn't the council as a whole. council doesn't get to decide that, you know, Councillor X from, I'll say District 22, because I know that's a safe district to use. The councillor for District 22 has a conflict. No, council doesn't get to decide that, but you do. Can other councillors comment on conflict concerns about a colleague who hasn't recused themselves? Yes, they can. There's some risk of defamation. As I say, there's some protection for mistaken but honest errors made at council meetings, but that wouldn't apply to a malicious comment in council. A malicious comment is defamatory even if made at a council meeting. So, you know, that's the situation, just so you're aware of. These things are in a slide deck because I've seen all these things happen. Non-financial conflicts, as I indicated at the outset, they're not legally recognized here, but they can result in challenges to quash decisions, particularly on subjects involving hearings or property rights of others, for example, where bias is alleged. You're biased on an issue, you don't have a financial conflict, you're on record as wanting an outcome of this issue, and yet you're participating in it. That can't be dealt with under the MCIA because it only deals with financial issues, but it may result in code of conduct issues or may result in a quashing of a municipal decision by a superior court. So I'm just going to click these slides. These were here in the pre-code of conduct days. The code of conduct, I think, adequately deals with these things, and I don't want to overdo it on that subject. So that's the end of this slide deck, and I'll look for some assistance to put up the next one, which I think is about in-camera meetings. Yes, questions, sorry. That's a good point. Questions?
Councillor
Has this changed in the last 15, 20 years?
No,
It hasn't.
the MCIA hasn't.
This is very
Yeah.
interesting.
Yeah.
I was a counselor here 10 years ago, and everybody knows that I worked for the Appledome Arena in Berwick.
I'm sorry, I didn't hear you.
Appledome Arena in Berwick. I managed that rink.
Yeah,
We came in and we applied for some money for the county. 2 or 3 counselors thought I'd be conflict of interest. So I went out and hired my own lawyer and had a letter from my lawyer that I am not conflict of interest because I'm not gaining a cent from it. I don't gain anything. If they don't give us any money, I still don't gain. If I got $2 million from the county and I don't take any extra money, I didn't gain anything. So I find this is really interesting because your views is different than 10 years ago. So I stayed in my seat and I was allowed to vote. As long as you don't gain anything.
that's not what the Act says. So I respectfully, I know I wasn't the lawyer giving
No.
that advice 10 years ago. I respectfully disagree with that bit of advice, and, you know, lawyers, like other professionals, don't always agree on things. That's all I would say about it. I don't agree that somebody who's in a central role for a volunteer organization which is seeking grant monies is not in a conflict of interest under this legislation. Clearly, the wording of the statute indicates otherwise, to my mind.
So if something comes up in 5 years from now or 3 years from now that the arena is hunting for some money for something, you telling me that I shouldn't stay in my seat?
If you're still in some kind of board or senior management role for that organization, that would be the advice I would give you.
Because I still have a letter from my lawyer stating,
Well,
I just want to be clear
yeah.
and I want to be clear to the fellow councilors, right? I mean, we got some other people here that have interest in other facilities that has been involved with facilities. Now they're not.
Mm-hmm.
Would that be any different what I am? I'm not going to gain a thing. I thought this conflict of interest, you have to gain something.
You or those parties who are deemed to be you, which includes these family members, it includes your employer, it includes organizations in which you occupy a central role.
Okay. I don't know what else I can say, but it's different. You said it never changed for the last 20 years, but it seems today.
The legislation hasn't changed.
But you can ask another lawyer, and he could give you a different, you know, every lawyer could be different.
Of course.
Yeah. Okay, thank you.
Ultimately, it's actually the court that would decide if it went, you know, if it went there. Wouldn't be, you know, your lawyer's opinion might have some value to the judge, but it may also have no value to the judge. Yeah.
Get you to turn off your mic there,
Oh,
Councillor
sorry,
Best, no problem. Councillor Sappington.
I have a question. I'm going to stick with my hypothetical situation only because I think I'm picking a safe topic that nobody is actually falling under. So, police officer, and my question also does, it references financial gain, because I feel like my example also isn't necessarily about financial gain. So, police officer's wife. Would a police officer's wife, if she was a counselor, have to recuse herself with anything regarding policing that comes up at council because her family member is a police officer? So I like that example because there isn't necessarily a financial gain, but it would be influencing regards to policing in the county.
So again, when we're dealing with this act, we're talking about financial issues, and there are some aspects of financial issues. For example, the contract with the policing service, a municipality may have a contract with the police force, which is the person's employer, or in this case, the person's spouse's employer, which are people of close enough proximity to be captured in the deemed conflict. So if that were the situation, then it would be captured here if it was dealing with, for example, the contract with the police service. But if it's dealing with other policing matters, you know, whether to, I don't know, concentrate on, you know, crime in the urban areas, or to put more patrols out in the rural areas or something, then it's probably not a financial issue, and therefore not captured by this legislation.
Councillor Gates.
Thank you. Through you, Mr. Mayor, could you define the term arm's length? I'd often hear that.
Well, I'm going to say no to that. I think in some ways the deemed degrees of proximity in here are telling you that they're considered to be you know, within arm's length. So I don't want to try to define a term like that in the abstract. Like, there's a lot of different sources, and it depends always on the context. Yeah.
Okay. We're good. Keep going.
Okay, we're moving on to another deck.
Okay.
In-camera meetings, and here I will give complete credit to Mayor Moutard. I did edit a few of the slides, but essentially this is Mayor Moutard's 2018 slide deck with my edits. So in-camera, camera is the Latin word for room. It means inside a room, and of course, in our context, it means inside a room with a closed door. What do they do in there? Well, this is at the heart of Section 22 is at the heart of this issue of Section 22 of the MGA. It applies both to council and to committees, and the interest that is advanced in Section 22 is that, with the exception of a limited number of topics, matters that are the subject of council debate and decision are to be done in open session, in public session, for full transparency. And Section 22 provides a list of items which are legitimate subjects of in-camera meetings. So when you're dealing with the acquisition, sale, lease, and security of municipal property, that can be an in-camera subject. And for example, if you think about the municipality trying to do a land assembly, let's say you're trying to build a sewage treatment plant and you need to pick up a bunch of parcels to make that happen, you can see why that's being dealt with in camera, because once the word gets out that you're in the buyer's side of the market, the price for that property is going to go up. So this is there to protect the municipal pocketbook. Setting a minimum price to be accepted by the municipality at tax sale. Obviously, the tax sale isn't going to be a very effective process if you declare the minimum price which will be accepted at the tax sale. Tax sales occurs when somebody hasn't paid their taxes or other charges that are collectible as taxes on their property for a certain period of time. And there's fairly detailed legislative provisions about them. Personnel matters, I've referred already to the privacy interests of employees. Personnel matters are dealt with in camera. Labor relations, that also is dealt with in camera for slightly different reasons. It's not so much privacy because presumably you're dealing with, you know, a group of some multiples of tens of employees usually. So it's not so much about privacy, but it's more like the first item here. It's, you know, it may be that your CAO wants to have an interchange with you about, for example, the amount of increases to give to collectively bargained wages during the time that a collective agreement is being negotiated. So again, that's to protect the municipal pocketbook. That's held in camera. Litigation or potential litigation, this also is dealt with in camera, and again to protect your interest. You know, maybe the lawyer is coming to you to report, oh, we have this civil lawsuit against us. You know, what's council's appetite to settle it for X dollars? Well, that should be carried out in camera, again, to protect the municipal pocketbook. It would also likely fall under the next category, which is legal advice that is able to be protected for solicitor-client privilege. And the law is very generous, probably because the law on the subject of solicitor-client privilege is largely developed by and for lawyers and ex-lawyers who are judges. It's very generous about protecting solicitor-client privilege. It allows me to give advice, me or my colleagues to give advice to council about a legal issue of some kind without having that advice be publicly shared. And that enables candor, you know, which is an important value for legal advisors and their clients. Public security matters, again, you don't want to be disclosing if you're trying to decide, oh, we have X number of cameras, where are we going to put them to protect our, you know, public safety interests with this event. You don't necessarily want that disclosed in public. So that's the shopping list. That's the entirety of the things that are to be discussed in camera. The legislation provides that no decision shall be made at a private council meeting except a decision concerning procedural matters or to give direction to staff or solicitors. And that would be to give direction to the CAO. That's actually the wording, I believe, is the CAO or solicitors. So you can give direction to your CAO or to your legal counsel in camera, but apart from that, decisions should be made at a public session of council. So often you'll see the practice, things are discussed in camera, there's maybe I'll call it a straw poll or a sort of a reading of the consensus of council at the in-camera meeting, and the decision is made, okay, we're going to enter into this contract with party X, and then you come out after the in-camera meeting, you come out to the open session, and you, in fact, pass a resolution to enter into that contract with person X. So that's how that process works. Discussion of these protected areas can take place in camera, but the ultimate action taken on them is done at the public session, with the exception of giving direction to the CAO and solicitors. Is there a public record kept of in-camera meetings? Yes, your agenda will say that council went into an in-camera section. It might say for solicitor-client advice, or it might say pursuant to section 22, subsection such and such. And that's really all that's said. It's not going to say, we went into an in-camera meeting to talk about entering a contract at the Walmart site. No. It won't say that. That's all that will appear in the public record on that. So this is an important one. What goes on in camera stays in camera, except to the extent expressly authorized by council. Any councillor or employee of a municipality who goes to an in-camera meeting, who discloses any report submitted to the in-camera meeting, or details of matters discussed, who said what, anything of that nature, the whole discussion is potentially triggering a personal liability of the person who discloses that information. Very important to honor in-camera meeting. It's a massive disrespect to your colleagues to leak information from it, and it has significant potential consequences for you in civil liability if you were to engage in that. And you'll also have noticed that it also can trigger a code of conduct sanction. So if there's a motion in the public session after the meeting, like in the example I gave, it doesn't remove the confidentiality of what was said or the documents that were shared in camera, except to the extent of what's actually incorporated into the motion. So if it's a motion to approve entering the attached contract, that's basically all. You can have, there can be discussion at the open session, but it can't be about what was said in camera. It has to be fresh debate and discussion, or even rehashed. It can be the same things that the councillor said in camera. Maybe the councillor can say in open session, but he can't refer to what was said in camera on the thing. And that's it for the in-camera deck, subject to any questions.
Councillor Lutz.
Thank you, Mayor, through you. In our last term, and particularly the last year, we had some pretty bad breaches of in-camera conversations. And one of the problems with that is that you can't always figure out who's speaking out of turn, to the point where, people were repeating things that counselors had said in camera on the street, knowing how people felt on particular issues in town. Like it was really, as a counselor, you didn't feel safe to actually, it was inhibiting, I think, council's ability to speak frankly about issues in private session, because we didn't know the whole point is that it remains confidential.
Yeah.
And so that was really difficult. And I don't think we tried very hard to determine, you know, I think we were just nearing the end of the term, and I don't know why, but there was no accusations made or no claims made or to who might be the person doing that. But it was really, it really fostered a sense of distrust, because you couldn't really participate fully as a counselor in these discussions, because you didn't know what, you know, we might as well have had it in public session was the feeling. So it was pretty frustrating as a counselor. So like what, I guess, if there's no way to find out who's doing it, then there's really no repercussions either.
Unless you can catch the perpetrator, you know, yeah, there are no repercussions, and obviously, the larger your council, the harder it is to find, you know, the perpetrator. This is a problem. This is a long-standing problem at municipal councils, and as you say, it really poisons the environment for those who respect the rules and the process. And, you know, all you can hope for is to, you know, is to catch the offending party. But, you know, you can't prosecute, you know, an unknown discloser. So, you know, I mean, I think you can always express as a body to the CAO, you know, whether there's some resources that can be applied to try to find out the answer to the question of how did this leak occurred. But it is very disrespectful, very, very disrespectful of your colleagues, presuming that your colleagues are respecting the rules and somebody is not, somebody's cheating. It's not good.
Yeah, thanks.
Unfortunately, I've seen in the past that sometimes discussion is made, and then eventually people have gone in camera, and then maybe at the end of the day, a counselor has forgot that the discussion was in camera and maybe made some comments, you know, not maliciously or whatever, and then you know, I've seen situations where other counselors or myself would have to say, hold it, you know, that was, oh my God, that's right, you know. So you gotta really, really be mindful that the discussion, when it was in camera, because sometimes discussion is at a regular meeting, and then you go in camera and take that same discussion a little bit further, you know, and it's very, very important to remember that now that in-camera part, you know, is confidential. So unfortunately, you know, sometimes I think, I mean, we're all humans. It is quite possible that people kind of, you know, forget that, oh, that part of it, you know, I'm not supposed to talk about. So I think it's very important for all of us to remember that, because sometimes it happens, and not because somebody is trying to breach the confidentiality. It's just they bloody well forgot.
That's a great point, and of course, it does require you to really, you know, really pay attention to what was said in camera and what wasn't, and that kind of thing, of course, can especially occur if there's multiple meetings, and you know, now maybe the thing that's being disclosed was something that was talked about at an in-camera meeting 6 months ago. Those types of breaches, they're unfortunate. They're not as blameworthy as the type of situation that I think Councillor Lutz was speaking of. Right. Yeah. There is one other thing I meant. There is one other thing I meant to mention about in camera and the general principle of open meetings. And sometimes it's hard to avoid what I call scope creep on the in-camera meeting. So you go in camera to discuss one of the legitimate 9 items, I think it is, or something like that, on that list. And you have to be careful that the discussion doesn't start to go outside of that area, and all of a sudden you're basically having a secret meeting about something that is, not appropriate for an in-camera meeting. So you have to be conscious of that as well. It's difficult. It's not easy. Like, it's a difficult process to keep a hold of, but you have to watch out about that scope creep, I call it.
See, Councilor McPherson, you had your light on, you?
Geez, Mr. Mayor, the light is very sensitive. My finger was near it and it went on. I don't think I pressed it.
It's not as bad as wishing for snow. Councilor Lutz.
Thank you. My final comment is just that I think for the majority of things we speak about in camera, they do eventually become public. It's a timing thing, and it's like managing the timing of when certain information is released, exactly for the reasons that Mr. Rogers has stated. That, like if we're talking about land, and then the price could go like all that. So I think one thing is, and I think I'm right in saying that, and that like the majority of stuff that we talk about in camera does eventually make its way into public session. Am I correct in saying that?
The majority, that is correct. Not everything.
Not everything.
Not everything. Like, as far as I'm concerned, solicitor-client advice should generally, generally that's never coming out. There may be a lawsuit or something, and that ultimately is public, but yeah, no, you're right. Most of those categories, the decision point is coming out because that's how you do your action. It's at the public open sessions.
Okay.
You'll be glad to hear that this is my last slide deck. It's been a long morning. And I say it's mine, but again, I have to give credit to Mayor Moutard for most of it. There'll be a few slides at the end that I take the blame for myself, dealing with, I think, in particular, planning hearings and other types of hearings that are mandated by the Municipal Government Act. And so the slides were derived by Mr. Moutard from the MGA. Your bylaw 64, I forget what it's called, but it's your council procedures bylaw. A text that is referred to in that bylaw, which is Burino. It's a text on parliamentary procedure. And, I don't think you want to end up having council meetings where everybody brings a copy of Burino and starts, raising all the very detailed things that can be there. But it's there to help backstop, in particular, the chair of a meeting on how to conduct the meeting and what the process should be. And derived as well from the Code of Conduct, and I'm sure Mayor Moutard was referring to the existing Code of Conduct, which is found in a capital P policy. And by the way, I'm sure others are telling you this, but all of your policies and bylaws are readily accessible on your municipal website, as are agenda packages and meeting minutes. What notice has to be given for a council meeting? For regular meetings, and I don't know when they are, you know them, I'm sure, but I don't know when they are. But every council, every municipality has regular monthly meetings, sometimes with a break for the month of August or something like that. That's standard procedure. And in a lot of municipalities, there are even also regular committee of the whole meetings, not always called committee of the whole. Different municipalities call them different things. But those are normal meetings which can be scheduled without having to give notice and advertise stuff. Special meetings, these are meetings that aren't scheduled as a matter of calendar routine. Councilors are entitled to 3 days advance notice, and the public to 2. Emergency meetings can be scheduled without notice. That's at the determination of the mayor, except when it's precipitated by a majority of council members. And in-camera meetings are generally scheduled. Okay, that's what this is here for. I removed some stuff on in-camera meetings because we covered it on the other slide. What's a quorum? In other words, what's the minimum number of councillors required to be in attendance? And under the MGA, it's a majority of council members, which means in your case, you need 6. The number gets adjusted if councillors declare a conflict and recuse themselves. That's provided for in the Municipal Conflicts of Interest Act. And that's to ensure that, you know, you're not all of a sudden creating quorum problems if 2 or 3 councillors, you know, declare a conflict in an issue. So bylaw 64, as I say, is it's enabled under the MGA. Almost I think every municipality has either a bylaw or a policy that deals with their council procedures, and the meetings are chaired. The meetings of council are chaired by the mayor, and in the absence of the mayor, the deputy mayor, and in the absence of both of them, a councillor appointed by council at the outset of that meeting. You can have substantive motions, which means anything other than a procedural motion or a question of privilege or point of order. And again, I'm not encouraging you to become scholars of these, you know, these fine points of privilege and points of order, because increasingly the public has little patience to see meetings where people are jumping up, raising these types of things. It doesn't mean that there shouldn't be procedural structure to a meeting. There should, and the chair should make procedural rulings. And normally, the chair's decision on procedural matters is appealable to the whole of council in case they went way off and got it wrong. So here's some procedural motions to refer, like maybe you're referring something to the CAO, maybe you're referring something to a planning advisory or some other special committee, a motion to amend, a motion to table a document or issue, a motion to extend the time of a meeting if there's a deadline in your procedures bylaw, which I'm guessing there is, a motion to postpone a subject to another meeting, and a motion to adjourn the meeting. Those are procedural motions. The rules say that councillors should not speak more than twice. It's probably honored in a lot of instances in the breach, and there are exceptions to that in your bylaw. You're allowed 5 minutes when you're debating a motion, and you get to get up a second time, and you have 2 minutes the second time, and ultimately the moving council member is allowed an opportunity to sum up after the councillors have all had a chance to speak and debate on the issue. Some of these procedural motions, you just make the motion and a vote is taken. An example of that is a motion to refer, except in certain circumstances. You can debate who the matter is being referred to, what specific information is being sought from the party to whom it's being referred, and when the matter is to be brought back to the floor of the council. But otherwise, you don't debate on the motion to refer, you just, you know, make a motion and vote on it. A motion to table or refer, everybody can speak once, and I assume the thing you're speaking about on the motion to refer is those 3 bullet points noted above. And this is Mayor Mutart reminding that decorum is required. And, you know, I'm sure most of you have enough experience to know that this is really an expectation. It is an expectation that has been whittled away, perhaps in the eyes of the public, by what you see on TV in some jurisdictions. You know, this isn't Congress. It's not a situation of anything goes. Politeness, respect are important attributes. Remarks should be addressed to the chair. Even if you're asking a question of another councillor, you would ask that question, and we heard good examples of this by several of you already. You refer the question through the chair.
I thought maybe you spelled my name wrong. You got D-E, I thought quorum there.
You should make your comments on the motion, not on some hobby horse that you feel like showing up, you know, on the video speaking about. You know, respect the necessity for relevance. Avoid making issues what the Latin people would call ad hominem, or about personal matters involving, you know, personalities, individual attributes. Try to keep them about the subject matter, not about the people as individual personalities. And avoid unseemly or unbecoming language. The chair can call to order or censure any councillor who questions the motives of another councillor, who threatens another councillor with disrespect. And it even says, which I wasn't aware of, this as an element of parliamentary procedure, but who passes between the chair and a councillor who's speaking, which I think is quite difficult to do at your council chambers. You can also be censured for using unbecoming language. Talks or acts so as to distract a councillor who's speaking. No slamming your books around, because you don't want people to hear that councillor. And you can be censured for violating on purpose any rule of council. A motion of censure or ruling of censure is subject to a right of appeal if the appellant can find a seconder, and the process is identified there at the bottom of that slide. The censured councillor actually leaves the room under this bylaw. A councillor can call a point of order if there's a breach of procedure, and the speaker who has the floor then, I was going to say should sit down, but you're probably already sitting, but you would normally turn your mic off so that the chair of the meeting can make a ruling on the point of order. Persons in the room who are not councillors or employees of the municipality who become disorderly or otherwise disturb the proceedings can be called out of order by the chair. And if they fail to comply, they can be ordered by the chair to leave the council chambers. And I certainly recall, I don't know, probably not many of you were around at the time that, you know, private garbage haulers were essentially being displaced by municipally contracted forces. I was in one council chamber where things got extremely heated, with a large number of angry people in a very confined space. And, you know, ultimately, at times you have to even call in the police. Hopefully that won't happen during your term as councillors. but it does have to be done in extreme circumstances. Members of council shall treat every person with dignity, understanding, and respect, and ensure that their work environment is free from discrimination, bullying, and harassing. And as you know, those things are already part of the slide deck we've seen on the Code of Conduct. And this slide simply refers that several of these issues are also dealt with in the Code of Conduct, and notes that Burino is a textbook about rules of order, rules of procedure, parliamentary procedure, some would call it, and it doesn't deal with conduct. A motion to reconsider can be made in some circumstances, and that's because, of course, council, like anybody, can occasionally have reached a conclusion too hastily, perhaps on the basis of inadequate or wrong information, and a later review may be in the interest of the municipality. So in that context, a motion to reconsider is available. It should never be used when a motion has been acted on. Too late to reconsider it then. You know, a motion to enter a contract with party X, the contract's been entered, it's too late to change your mind. The process for reconsideration motions is not outlawed in Bylaw 64. There are technical restrictions which are of debatable applicability. There was more slide deck points in the previous edition, which I've taken out here. Some people argue that a motion to reconsider should only be brought by a councillor who voted in favor of the motion that is being reconsidered. For the obvious reasons, you don't want to just be having the dissenting side, the losing side, putting the issue back on the table for the same vote. That's just a waste of everybody's time. And I like these overall considerations here. Modified parliamentary processes that you will be using, they should allow for debate. They should allow for dissent. There's nothing wrong with dissent. Collegiality does not imply everybody thinks the same about everything. But they should allow for respectful dissent, public accountability, transparency, while respecting other values like privacy rights. When the chair makes a procedural ruling, unless it's overruled by appeal to council, the ruling is final, and council moves on to the next item, leaving past process issues behind. You know, you don't raise a process issue from the last meeting at the next meeting saying, well, I've got my Burino out here and you were wrong about the point of order. No, no, that's done and dusted. It's all over. The process needs to respect the need for finality on substantive matters which have been acted on, while also allowing council to innovate and make changes to reflect societal changes and real-world experience with past decisions. So when I say respect the need for finality, what I mean by that is while the majority needs to respect the rights of dissent of council members who don't agree with them, the dissenting councillors have to respect the majority rules principle. And when the decision is made, that's the decision. You know, absent a successful motion for reconsideration, finality is an important thing to stop you from wasting your time on stuff you've already dealt with, because you have a ton of stuff to deal with. Committees. In-camera restrictions apply to committees just as they do to council. Same subject matters only permitted. And it applies to non-councillor members on those committees too. If there's an in-camera meeting of a committee that includes non-councillor members, they have to respect that process. The mayor is an ex officio member of every committee or subcommittee, even if not appointed to it. That means that the mayor has a voice, but in most circumstances, not all, but in most circumstances, doesn't vote at committees at which he is not an actually, appointed member or a member, because all councillors are members, which is the case for some committees. But if he's only an ex officio member because of his status as mayor, he has a voice but no vote most of the time. There's an exception to that, which I won't bother with, but councillors are under this. This is under your procedures bylaw. Councillors have a duty to report the creation of a subcommittee by a committee that you're on, the creation or termination of a material contract, matters which may have a financial impact on the municipality, matters which may give rise to liability for the municipality, and any material information that may affect the interests of the municipality. So those where you're a representative, and maybe you're one of 2 council representatives to a certain body, these are the things you're expected to report back on. And I'm not sure if your agenda regularly includes an item of councillor reports from committees, but whether it does or not, you need to report these matters back. The chair of the committee is to report attendance at committee meetings to the municipal clerk on a quarterly basis. And each person appointed to a committee is to report to the clerk their attendance for the obvious purpose of dealing with that disclosure. You cease to be a member and can't be reappointed to a committee if you miss 3 consecutive meetings without a cause which is accepted by the committee. And you'll often see at council meetings that a council member has excused themselves, maybe for a medical procedure or otherwise. That doesn't count as being, an absence that will trigger, consequences. It says make every effort to arrange for another council member to attend as an alternate, and your absence won't be counted if the alternate has agreed in advance of the meeting to attend. Hearings. Now these are mostly my slides, this section of it. The legislation stipulates council must have hearings or public hearings for certain things. One of them is the ordering of destruction of dangerous or unsightly premises under Part 15 of the MGA. Another one is registration of a municipal heritage property. Those have to be done in particular if somebody is trying to register a heritage property against the will of the property owner. So the property owner would have a right to have a hearing on that. The adoption of land use planning documents calls for a public hearing, and again, land use planning documents, the MPS and the LUB, when you're amending those, as you do periodically, you have a public hearing with advertisement in advance, a first reading, and then a public hearing at which members of the public get to speak. As well, your hearings on development agreements and land use bylaw amendments initiated by an owner. You have a public hearing there. The word hearing is a signal for lawyers and courts. When that's in legislation, whether it's subordinate legislation or whether it's in a statute like the MGA, it signals that due process is involved. And, giving an affected property owner a fair chance to be heard and to respond to complaints which maybe have been made, and I give the example here of a dangerous and unsightly situation, that property owner has a right to come in and say, well, wait a minute, here's why my property looks the way it does now. Here are my personal circumstances. You know, there may be mental health or other issues involved. There may be all sorts of issues. They get to make a presentation before you order their building to be knocked down, their house to be knocked down. Yeah, they get a hearing for that. Counselors should not be closed-minded, and that's the legal test for bias of counselors on some types of issues. You should have an open mind. You're allowed to have opinions. You're allowed, some people were elected, you know, on a platform of a certain kind. You're allowed to have predispositions towards, I don't know, saving heritage properties or old properties. You're allowed to have predispositions for certain things. But you must respect due process to the extent that your mind is not completely closed in advance, that you're willing to hear and, in extraordinary circumstances maybe, change your mind. You need that bit of open-mindedness to pass the legal test for not infringing the law against bias that is applied by the superior courts when they're reviewing hearings undertaken by municipal councils. This last bullet point is something that I think I've seen often happen, and so I like to put in a reminder in it. If you have information that you want to rely on in the debate after the hearing, let's say it's information that nobody talked about in the public, you know, presentation prior to the hearing, and after that hearing is, you know, the public has been heard from, the property owner has been heard from, and the chair has said, okay, we've reached the end of the public hearing. We're now going to have our debate and decision about this matter. It's important that you not withhold information that is in the nature of factual evidence. It's important you not withhold that information and blurt it on the table in the council debate when the affected parties have no ability to respond to it. So, you know, if you have something that you think is important to the decision, ask a question which includes that information so the owner has a chance to respond to that. That's the best way to do that. The public has a right to participate in public hearings, such as the planning application hearings I talk about. Their procedural rights can be limited, such as by speaking time limits. I think yours is 10 minutes at your planning hearings. I know HRM is 5-minute limits, but these time limits are there. Your chair has, you know, doesn't always enforce them, but they can be enforced, and sometimes they probably should be enforced. How good a process is it to have a 6-hour public hearing is probably not great. People are tired. They're not, you know, they're not at their best. So, you know, these time limits in particular should be enforced by what I call, you know, third parties. People whose property isn't directly affected, but only indirectly affected. It's wise to have a standardized opening script for the chair at these hearings to encourage orderly and respectful public participation. Same should probably be done at the PAC level. And you don't want these public hearings to turn into like a sports event where somebody gets up and they attack, you know, a development proposal, and, you know, you have wild applause from all of the other people who oppose it. It shouldn't be like a sports event. It should be a respectful thing. You should keep in mind it is a hearing. So you want to encourage respectful participation and trying to keep things in hand, trying to avoid having members of the public attack your staff, as happens too often. I hear this I act for multiple municipalities. This is an increasing problem in the social media age where staff have to give their opinion. They don't have the choice. They have to make a recommendation. And their professional responsibility requires them to make it based on the planning document. So they don't have a choice in what they're doing. I mean, of course, they have to formulate their opinion and make a recommendation. They should not be subjected to abuse for doing that. They have a duty to discharge. And, you know, to the extent possible, council should try to protect them from abuse. You don't want to lose staff people because of that kind of conduct. As I say, this is running rampant. You know, it's sort of a product of, I'll call recent times, that it's gotten a lot worse. Members of the public can have widely differing interests in the subject matter, but sometimes it's worth keeping in mind when you're dealing with planning restrictions. The primary, I call them the regulatory counterparty. The primary person who is being controlled by the regulation is the landowner. Because in the sort of pre-regulatory world, when there was, let's say, no land use planning in many of the rural areas of this province, those people had the right to do anything, almost anything, not quite anything, but almost anything on their land. They couldn't pollute, they couldn't do certain things, but they could do a lot. And that's what land use bylaws do. They restrict the owners from doing some certain things and from developing. The landowner is the primary regulatory counterparty, and some respect for their ownership interests, which may have cost them a lot of money, or which may have been handed down generationally in their family or whatever. Some respect is owed on account of that. For planning applications, you will get a staff report, and you don't have to accept the recommendations of your professional planners in all cases. There are things that call for judgment. I gave the example, I think, of wordings like, you know, is it compatible? Well, when you see that kind of word, there's room for disagreement. Two reasonable people may come to different conclusions on whether something's compatible or not. But what you do need to keep in mind is you're not just deciding the way you would like to decide this application. You have to have a reasonable basis in your planning strategies for what your decision is. So if you're going to refuse a planning application that has been recommended by staff as being consistent with the municipal planning strategy, you need to articulate why it is that you say approving this is not consistent with the planning strategy. The debate is supposed to be around the application and interpretation of the planning strategy, which is your document. Your document because you were the ones who passed the bylaw that constitutes the planning strategy. Repeated behavior of council not following through the criteria in the MPS can result in authority being taken away from you. And I've given an example here that I think most people have probably heard of in the HRM, where their planning authority was severely curtailed as a result of issues of that nature. Whoops, I think I goofed there. Oh, maybe that is the last slide. That is the last slide.
The last slide, okay.
Questions?
Very good, thank you very much. Very, very thorough. All right, we have any questions of council? Guess maybe everybody's getting hungry. All right, we do have Councillor Lutz.
Just one quick, it's actually not even a question. It's just I don't think I'd ever seen before the duty to report from committees to council. So I'm wondering if we could get that, like if our staff could just send out that list, because we are required to report our committee meetings at each meeting of council and what we've attended, but I had not seen like a comprehensive list before of what exactly we needed to report on, and that it will be very helpful, I think, in putting together those committee reports every month. So thank you.
I'll be candid, I hadn't seen that list before until I saw Mayor Moutart's slide deck. I'm assuming, I mean, he's, you know, I assume he's taking it out of the procedures bylaw. I don't think it would be there otherwise, but.
Okay, perfect.
Yeah.
Thanks.
Okay. Okay, well, thank you very much, and I guess I'm going to ask for a motion to adjourn, please. Moved by Councillor McPherson, second by Councillor Best. We'll get you all to touch your button. It's not lit up? All right, all those in favor signify by raising your right hand. Motion carried. Thank you. All right. We didn't wait long enough. I'm not patient enough, I guess. Thank you very much. Excellent job.
Thank you, Mayor. Thank you, Mayor.